Well, good evening, everyone, and welcome to the first Stand Up for Your Rights webinar for 2022. My name is Bruce Maguire. I'm the Policy Advisor with Vision Australia, and I have the pleasure and privilege of being the facilitator of the webinar. Tonight, we're going to have a good time together as we explore the question, how do you make your disability discrimination complaints matter? But before we launch into our topic, I do want to acknowledge the traditional custodians and owners of the various lands that we're gathered on for this virtual event, including the land of the Wallomedegal clan of the Darug Nation, where I'm located. I pay my respects to elders past, present and future, and I also extend that respect to any Aboriginal or Torres Strait Islander people who are participating in the webinar tonight. Now, one thing I'll just mention before we go any further is that we are recording this webinar, and the reason we're doing that is so that we can send the link to the recording after the webinar in the next few days to all people who've registered, including, of course, people who aren't able to attend tonight. So tonight's webinar is the latest in a series that Vision Australia's Government Relations and Advocacy team has conducted over the past couple of years. The series has been sort of generally based on topics that are covered in our Stand Up for Your Rights self-advocacy guides, and they are resources that our advocacy team have produced now, and we have quite a number of them, and you can find those guides by going to our website and searching for Stand Up for Your Rights, or if you can't find them that way, you can email advocacy@visionaustralia.org, and you can ask for more information about them. So as I mentioned before, the topic of tonight's webinar is making your disability discrimination complaints matter, and we'll be zeroing in particularly on the Commonwealth disability discrimination and New South Wales anti-discrimination legislation. In a few moments, I'm going to introduce our three-member panel, and they'll be providing their expert perspectives on how people who are blind or have low vision can use the Commonwealth Disability Discrimination Act and the New South Wales Anti-Discrimination Act to lodge complaints, of disability discrimination, and in particular whether one might be better than the other or more suitable, in a particular case. But before I do that, I just want to go through a couple of housekeeping things so I can get those out of the way. And the first one has to do with asking questions. We're actually providing two ways for you to ask questions throughout the webinar. The first way is to use the Zoom chat feature, which allows you to type in your question. Now, some of you may already be very familiar with that, with the chat panel in Zoom, but if you're not, you can open it by using Alt-H if you're on a Windows computer, or Command-H if you're on a Mac, and if you're using a smartphone, you swipe around until you come to the Open Chat button, and once you open that chat panel, you have to type in the question. The second way that you can ask a question tonight is to use the raise hand feature in Zoom, and that has different options depending on whether you've dialed in using a telephone, or whether you're using Windows, or whether you're using a Mac, or whether you're using a smartphone. If you've dialed in, I don't know whether anyone has dialed in, but if you have, you can indicate that you want to raise your hand by pressing *9 on your telephone keypad. If you're using Windows, it's Alt-Y, and if it's Mac, it's Command-Y. And if you're using a smartphone, or certainly with an iPhone, you swipe to more and then swipe to raise hand. Now, so that's the first. They're the two ways you can ask. You can ask the question. Now, Phil McCarroll, who is Vision Australia's Media Relations Manager, is here helping tonight to make sure that everything runs according to plan. And Phil's going to be monitoring the chat and the raised hands. Now, at various points as we go through the discussion, I'll be asking Phil if there are any questions in the chat, and if anyone's got their hands raised, and if I forget to ask him, he'll remind me. And Phil will select questions and read them out for the panel to answer if they come through the chat. Now, if you've raised your hand, what will happen is that Phil will send you a request to unmute your audio, and once you've received that request, you have to unmute yourself using Alt-A or tapping the unmute button or *6 on a telephone, and then you'll be able to speak your question directly to the panel. Please bear in mind that you will need to unmute yourself, as hosts can't unmute participants in webinars. So if you don't feel comfortable doing that, and if you don't feel comfortable using the chat either, then the best way to submit a question is to send it to us by email after the webinar. And if you do that before this coming Friday, which is the 11th of February, we will submit those questions to the panel, and you'll get a written response. And if you want to email a question, the email address to use is advocacy@visionaustralia.org. That all sounds very complicated, but once you actually start doing it, it's much simpler than it sounds. But if you do ask a question, please, we do ask that you make sure that it's related to tonight's topic, because we only have 75 minutes, so we want to make sure that the questions that we do cover are relevant to as many people as possible who've joined us. And please also keep any questions that you ask general, because we can't give advice about individual complaints. Okay, so now it's my pleasure to introduce our expert panel. And the three-member panel are Joanna Dorinova from the Australian Human Rights Commission, Molai Kamara from Anti-Discrimination New South Wales, and Sarah Hartley from Vision Australia. Now, I'm going to ask each of the panelists to introduce themselves and talk for a couple of minutes about what they do and the main activities of the organisations that they represent, and how what they do kind of meshes in with those activities. We'll start with Joanna. I first met Joanna when she was a student at Macquarie University and president of the Macquarie Association of Students with a Disability. And I have to say, Joanna, that sometimes feels like it was only the day before yesterday, but Joanna is...
Going on 30 years, Bruce.
Yes, and because after Joanna completed her study, she's been working at the Australian Human Rights Commission for the past 16 years. And Joanna is now a senior investigator and conciliator in the Commission's Investigation and Conciliation Service. And I'll let Joanna talk more about what that means in practice. So welcome, Joanna.
Thank you, Bruce. Hello, everyone. And I too would like to acknowledge that I'm actually coming to you from my home, which is on Guringai land. So I would like to acknowledge the traditional owners of that land and their elders, past, present, and emerging. So Bruce is correct. I'm a senior investigator and conciliator in the Investigation and Conciliation Service of the Human Rights Commission. So the Australian Human Rights Commission is Australia's national human rights institution. So that means you're actually accredited with the United Nations as a national human rights institution. And our powers and functions are all set out in the Australian Human Rights Commission Act, and we have a number of powers and functions, and they mainly relate to the investigation and conciliation of complaints alleging unlawful discrimination and breaches of human rights, educating the community about the importance of human rights and the protection of those rights. And then there are a whole range of functions around providing policy guidance and advice to government, providing advice on legislation, conducting inquiries on systemic issues, which can be what's referred to as an own motion inquiry, so where the Commission initiates that inquiry, or where government asks us to conduct an inquiry. Probably the most recent example of that was the inquiry into sexual harassment in parliamentary work settings. So we're quite, for all that, we're actually quite small, so as an agency. And the section that I work in is the section that actually investigates and conciliates complaints. So we can accept complaints under a range of federal legislation, because unlike the state legislation, which has a single act that kind of covers everything, we have 5 different pieces of legislation that we're working with, and today in Parliament they're discussing a possible 6th, so in the religious discrimination bill. So the main grounds, I mean, I won't go into the particular legislation, but essentially the grounds that you can, and by grounds what I mean is I'm being discriminated because ... Those grounds include disability, as you would know, and that includes past, present, future, and imputed disability, which is when someone thinks you have a disability, association with a person with disability, use of an assistance animal or device, use of an attendant, and so those are the disability grounds. Then we can also inquire into allegations of age, race discrimination, which covers colour, ethnicity, national origin, immigrant status, and ethno-religion. And then our Sex Discrimination Act covers grounds such as sex, gender identity, intersex status, sexual orientation, relationship status, pregnancy, breastfeeding. And have I forgotten any? I think I've got most of the grounds. And the general gist is that what you're having to allege when you allege discrimination is that you're alleging discrimination in an area of public life. So that usually includes things like employment, education, goods and services, access to premises, and so forth. And it can be either direct or indirect discrimination. So direct discrimination is when someone treats you less favourably because of a particular attribute that you have. And indirect discrimination is when there's a requirement or condition which appears to apply equally to everybody, but you can't comply with that requirement or condition because of your disability, and that requirement's unreasonable under the circumstances. So that's kind of broadly what you can complain about in the unlawful discrimination space. We can then also inquire into equality of opportunity and employment on the basis of a number of grounds, which include religion, criminal records, trade union activity, and some others. And we can also inquire into alleged breaches of human rights by the Commonwealth or agents of the Commonwealth. And human rights are basically the human rights set out in international conventions that are either declared or included in the Australian Human Rights Commission Act. So it's quite a broad scope of things that we can inquire into. Generally speaking, the process is that we will conduct a certain level of investigation into a complaint, but primarily our goal is to try and help parties resolve that complaint through conciliation, which is a form of dispute resolution. So where the Commission essentially sits as an impartial third party and attempts to help the parties discuss issues and options for resolution. If a complaint is resolved, then that's great. The matter's simply finalised. If it can't be resolved, then the Commission may terminate the complaint, and the person has the option of taking the matter to the Federal Court of Australia or the Federal Circuit and Family Court of Australia to have the matter heard there. So that's kind of in a very broad strokes what we do. Things get a bit more complicated in the human rights space. I can talk about that more if people have particular questions about that. It's important to say that you can lodge complaints on your own behalf, on behalf of someone else if you've got their consent, or on behalf, you can have a whole number of people lodging a complaint together. You can lodge a complaint on behalf of a class. So an example of a class might be, we've had complaints about the lack of accessibility of train stations on behalf of residents of a particular suburb, for example. And you can also, just trying to think if there's anything sort of material that I should get out of the way now. But probably I'll leave it for now and then maybe try and address things through the questions might be better use of time.
Thank you, Joanna. And yes, I'm sure some of the issues you've touched on there will come up again when we sort of look at the questions that we're going to use to guide the discussion.
Sorry. The thing that I wanted to make really clear is you can also lodge what I guess people would refer to as intersectional complaints. So we often receive complaints again, like relating to, for example, disability and sex, or disability and sexual harassment, or something like that. So you can have multiple grounds to a complaint. So that's what I wanted to say.
And that's good. That is certainly good to know, because intersectionality is one of the, quite a trending topic at the moment.
Yeah.
So I'm now going to introduce our second panelist, who is Morlai Kamara, who's the Community Engagement Officer at Anti-Discrimination New South Wales. Morlai has experience in community development and human rights and policy in both government and non-government sectors in Sierra Leone and also in Australia. And prior to joining the team at Anti-Discrimination New South Wales, Morlai had worked for the Australian Human Rights Commission, Settlement Services International, and Core Community Services. Morlai, we're really looking forward to hearing more about you and Anti-Discrimination New South Wales, and it's great to have you with us tonight. Welcome.
Thank you very much, Bruce. I also start by acknowledging the traditional owners of the land that we are connecting from tonight. I pay my respect to their elders, past, present, and emerging. Thanks once again, Bruce and Susan, for inviting Anti-Discrimination New South Wales to be part of tonight's session. Like Bruce said, my name is Morlai Kamara, Community Engagement Officer at Anti-Discrimination New South Wales. I'm really delighted to be here tonight to participate in this Stand Up for Your Rights, Making Your Discrimination Complaints Matter session. I find the topic for the webinar quite appropriate. It is as appropriate as its timing. I say so because during this pandemic, the level of disadvantage and discrimination experienced by people with disability, be it in accessing employment, in accessing goods and services, in education, etc., have been amply highlighted by people with disability themselves, by peak bodies like Vision Australia, and by the Disability Royal Commission. So there are quite a lot of issues currently that have been brought to light and during this period for people with disability. And in our experience at Anti-Discrimination New South Wales, we have actually seen an increase in the number of disability discrimination complaints, which actually accounted for 29.7% of all complaints that we received for the 2020-2021 reporting period. So it's therefore very important to organize sessions like this to talk about how members of people with disability will be able to use the states, but also federal bodies to be able to lodge their disability discrimination. So it's a very good opportunity. I understand that there are members here tonight who have come from different parts of the country. A lot of everything that I'll be saying actually is going to be based on the Anti-Discrimination Act of 1977, New South Wales. And a lot of what I'm going to say also is going to be in response to the questions that we received from Vision Australia before tonight's session. So the Anti-Discrimination Act of 1977 in New South Wales is an act to render unlawful racial, disability, and other types of discrimination in certain circumstances, and also to promote equality of opportunity between all persons. The Act creates the role of an independent president and board, and Anti-Discrimination New South Wales supports the president and the board in their functions. So Anti-Discrimination New South Wales is part of the Department of Communities and Justice. And the main functions of Anti-Discrimination New South Wales are answering inquiries, resolving discrimination complaints, raising awareness about discrimination and its impact, managing applications for exemptions from the Act, advising the government of New South Wales about discrimination issues. So discrimination under the Act is actually treating someone unfairly because of a characteristic they have or are assumed to have that is protected by New South Wales law. Under the Anti-Discrimination Act of 1977, the following are grounds of discrimination: race, disability, homosexuality, transgender, carer's responsibility, age, marital or domestic status, sex, including sexual harassment, pregnancy, and breastfeeding. And for tonight's session, a lot of what I'm going to be saying here will be focused on disability discrimination. And under the Act, disability is defined as loss of bodily or mental functions, physical disfigurement, illness and disease, including psychological illness. And discrimination happens because the person has a disability, is thought to have a disability, or is associated with someone with a disability. So broadly, those are the functions of the, those are the areas covered, the grounds covered within the Anti-Discrimination Act of 1977. And our main function as Anti-Discrimination New South Wales, like I said before, is to provide support to the president and the board of the Anti-Discrimination Board to be able to perform these functions. I am a part of the community engagement team, and our role is to increase awareness about discrimination in the New South Wales community, but also highlighting the impacts. And we do that in many forms, including the development of information resources for our website. We've got a brand new website which has been upgraded recently. I encourage you to visit it. It's quite, there's a lot of resources in there. And we also, through the community engagement, work with different stakeholders like peak bodies. We try to build working relationships with stakeholders both within and outside of government, with the aim of ensuring that the community is fully aware of issues of discrimination. They know about the Act, and they know that we are here to support them through issues of discrimination. So under the Act, there's also issues around two types of discrimination, which Johanna mentioned already. I'm not going to touch on that again, the issue of direct and indirect discrimination. And there are particular public areas of public life where the discrimination should take place for us to be able to act on them. So employment, that is at work or when you are trying to get a job. Goods and services, that is in shops, in banks, using government services, in cafes, hospitals. We also cover public education, so public schools, TAFE, New South Wales, universities. Accommodation is another public area that is covered. So renting a house or a flat. and registered clubs. So any club that sells alcohol and or have gambling machines. So those are the areas that we cover in the Act, the New South Wales Anti-Discrimination Act. I will pause my opening remarks at this stage and hopefully provide more information during the next segment of this session. Thank you.
Thank you, Molai. That's a lot of useful information there, and it's been a great pleasure to have had the opportunity to work with you over the past couple of years. Unfortunately, since the pandemic, we haven't actually met in person, I don't think, but it's certainly good. We've had quite a lot of useful discussions of Vision Australia and Anti-Discrimination New South Wales. And speaking of Vision Australia, I now want to introduce our third panelist, who is Sarah Hartley, and Sarah is an advocacy advisor with Vision Australia, and Sarah is based in Queensland, and she's worked for Vision Australia for 6 years, and prior to that she worked in state government for 6 years in areas that included access and equity and adult community education and contract management. Now Sarah is a lawyer by education and training, and so she provided advice at a number of community legal centres for 3 years. Now, during her time at Vision Australia, Sarah has provided support and advice to individuals facing barriers to participation in the community due to their blindness or low vision. And in addition, she works with the advocacy and government relations team to address systemic-wide barriers in the community. Sarah, I'm sure you could talk at length, for many hours about all of those barriers, that we know people experience. But I will ask you to just talk, sort of, summarise what you think are the key issues, and a very warm welcome to our panel this evening.
Yes, thank you, Bruce. Yes, my name's Sarah Hartley. I've been working with Vision Australia as an advocacy advisor, which has been very enjoyable. As you mentioned, I've got a legal background and I'm admitted as a solicitor. And on a daily basis, I talk to clients who call in with individual issues that they've come across. So we provide advice and assistance for people who are facing barriers to participating in day-to-day life, in community life. So that might be something like relating to education, their school or university, for example, getting accessible information. It might be employment. It's also access to goods and services. So it might be something like someone with a seeing eye dog has been refused service at a shop or a cafe or a restaurant. So in that situation, we give people initial advice, and we also help people if they would like to do some self-advocacy, then we can give them some advice if they'd like to self-advocate. And we can also advocate on their behalf with their permission. So they may give us consent to contact the organisation or the restaurant or the employer or the tertiary institution, for example, and see if we can resolve the issue. The other thing that we do is if people would like to proceed with putting in a discrimination complaint, either to the State Commission or the Australian Human Rights Commission, then we can sort of provide some advice and also assist them to draft a complaint and help them with submitting it. And if that complaint is accepted by either the state or the federal commission, then we can provide support in terms of coming along with them on the day of the conciliation conference and assisting with negotiations, opening statements, and just providing support for them on the day during that process. We also do some systemic work. So we represent Vision Australia on various government committees and councils. There's also some government lobbying and media campaigns that happen to do with issues that are relevant to the blind and low vision community. So that's That's what we do. I'm actually legally blind myself. I use long white cane for navigation and also screen reading software for accessing information. So yeah, I really enjoy working with the clients, and I'm happy to talk about disability discrimination complaints tonight.
Thank you very much, Sarah, and you'll certainly get the opportunity to talk more about your work and give your perspectives on some of the questions that we're going to be talking about. So, but look, now that we've heard from Joanna and Morlai and Sarah, we are going to have a discussion about disability discrimination complaints. And before we start that discussion, I just want to remind you about questions. If you want to ask a question, I use the chat or raise your hand. And after we've kind of dealt with the first question, I think I'll ask Phil to give us an update on whether there are any questions in the chat or raised hands. Now, I think all of us, as people who are blind or have low vision, experience discrimination in various aspects of our lives. I think sometimes we experience discriminatory barriers every day, and sometimes we experience them more than that. And I think it's true that most of us, most of the time, try to resolve barriers that we kind of encounter through dialogue with the people who ultimately cause the barriers. But there are times when we at least do some serious thinking about lodging a complaint of disability discrimination, either using the Commonwealth Disability Discrimination Act in 1992, which we've had now for just about 30 years, or one of the Anti-Discrimination acts in the states and territories, and specifically the one that we're talking about tonight is the New South Wales Act for people who live in New South Wales. So the first question I'd like to ask our panelists is what are some of the key things that people need to think about when they're considering lodging a disability discrimination complaint, so that they'll get the best result if they do go ahead with it? And I'll ask each of the panel to kind of share their perspectives on that question, and who'd like to open the batting on that one.
I'm happy to speak, Bruce. When we're contacted by a person who's blind or has low vision about a potential discrimination issue, we sort of start off by asking a few questions. So we'll sort of identify which state the person lives in. So that gives us a bit of an idea of, what jurisdiction may apply. We also identify which state the incident occurred in, because sometimes people might be travelling and it might be an incident that's occurred with, say, an accommodation provider interstate. Also, when the incident occurred, because there are time limits, which I'm sure that the representatives will speak to in terms of when you can put in the complaint. We'll also talk about the facts of the incident. So we recommend that clients keep notes about dates and times of conversations, who they spoke to, who they communicated with, any agreements that were made in conversations, any emails that might have related to the incident that they can sort of refer to later. We'll also talk to them whether it falls within the areas that are covered by the state legislation and the federal legislation. So does it fall within sort of goods and services or clubs and organisations, and just make sure that it does fit. Often it's employment, education, goods and services. They seem to be quite common areas, unfortunately, where people do encounter discrimination or barriers. We'll also look at whether it's likely to be considered direct or indirect discrimination. So there's a few elements there about being treated less favourably. Also, indirect discrimination can be, a test or a requirement, as Joanna mentioned. So we'll just sort of see whether their situation fits in that situation. And we'll also look whether it's primarily a reasonable adjustment issue, because depending on the state, if there's not specific provisions for reasonable adjustment, then maybe we'll be looking at the federal legislation to put in a complaint there, but it does depend on people's jurisdiction. And we'll be looking at the outcomes that the client's seeking. So sometimes the client does wish to resolve it informally and doesn't want to go to the point of making a formal complaint to the Commission. Other people would like to they've attempted to self-advocate and unfortunately have been unsuccessful and do want to proceed with a disability discrimination complaint. And we can help them in that situation. We talk to them about the options. We can do some sort of advocacy with their permission. We can contact the organisation and try and resolve the issue. But if they don't want to do that, or it hasn't been successful, then we'll talk to them about the state legislation and also the federal legislation. And a couple of things that we mention is that there's timeframes involved. So if you do put in a formal complaint to either the state or the federal commission, it's not something that's going to be resolved in a matter of days or weeks. It's more likely to be months. And are they, comfortable with that? And also costs. We'll talk to them, okay, if there's a conciliation conference and an agreement is reached, that's great. But if it doesn't occur, if there's no agreement, then the matter may go to either a state tribunal or a federal court, and there are costs associated with that. So we'll just give people information about that so they can make an informed decision.
Thank you, Sarah. And so I think it's pretty clear that there are quite a number of issues that certainly from Vision Australia's perspective, it's good for people to think about, and our advocacy team are able to help you sort through all those issues. Joanna,
Yes.
do you have anything? How does that sound to you from where you are in the federal system?
Yeah. Very sensible. Thank you.
Mm-hmm.
Thank you, Sarah. Look, I think the thing, and I noticed something came up on the chat about how do you know you've been discriminated against. It's kind of one of those things, like if it looks like a duck and quacks like a duck, it's probably a duck. So if you consider that someone is treating you less favourably because of your disability, then potentially it's an arguable complaint. And certainly we do not want the onus of people making assessments that they can't lodge a complaint to be on the complainant. This is why both I'm sure AD&SW and certainly we have a national information service where you can call and go, this happened to me. Is this something I can make a complaint about? So, and that is actually what I would suggest people do. If you think something's happened, whether it's at work or in transport or a shop or whatever, and you think, I think I might want to make a complaint about this, certainly all the stuff that Sarah was just talking about, like be prepared for the fact that it's going to take months rather than days, most likely. That you are entering a we try to make our processes as accessible as possible, but it is a process that you're going into that has certain constraints and kind of realistic outcomes associated with that. There are timeframes. In our case, ideally, if you're lodging a complaint alleging unlawful disability discrimination, the timeframe is ideally 6 months. Now, in our case, we can actually accept older complaints. It then becomes at the President's discretion whether we pursue those complaints or not. So if it's been 6 months and 3 days, don't kind of go, oh, that means I can't lodge a complaint. If it was 21 years ago, we might say, look, it's not really going to be fair to the respondents for us to progress this matter. But so don't necessarily be knocking yourself out for that reason. What I would say is the thing that I would tell people not to do is don't do the scattergun complaint. When you send a form to AD&SW, you send a form to us, you send a form to Fair Work Commission or to an ombudsman, because what that can mean is that you might be locking yourself out of options, because different agencies might have provisions that mean that, for example, the Fair Work Act says that you cannot lodge a complaint in 2 places about a dismissal. So if you lodge and this has happened to people, so someone might have lodged a complaint with the Fair Work Commission alleging unlawful dismissal on the grounds of disability, and they've lodged a complaint at more or less the same time with us alleging disability discrimination. Because the complaint with the Fair Work Commission was lodged 2 minutes before ours, we have no jurisdiction to handle it. So my advice would always be, call Vision Australia, have a look at the websites, call the various, most statutory agencies have an information service. So whether it's Ombudsman or us or Fair Work Commission or the Industrial Relations Commission in New South Wales, call and find out, look, this is what's happened to me. What do you cover? Is this covered for you? And what's involved in making a complaint? What happens when I make a complaint? And that should give you a little bit of guidance of where the best place for you to go is. Sometimes you're not going to have an option. If you're making a complaint about a Commonwealth agency, you have to come to the Commission. The Anti-Discrimination New South Wales can't inquire into complaints against the Commonwealth. If you're talking about a private school, you would need to come to the Commission. Sometimes the definitions are slightly different. Or as Sarah was explaining, if you've got an event that happened in Queensland while you were travelling there, you may not be able to go to the Anti-Discrimination New South Wales. And depending on the provision of that state's law, you may not be able to go to the Queensland Commission either, because you might need to be a resident of that state. So that is often where we come in, where there's kind of people in different states or internationally for that matter. So there's all sorts of complexities that might affect whether you should go to the state or federal jurisdiction. And my suggestion is call both, have a bit of a chat to both agencies, and then make a decision based on that discussion. Reality is that sometimes it's kind of much of a muchness as to which one you go. It's a very small proportion of matters that go to the tribunal or the court. So really your major consideration is just who can hear my complaint and do I like the service I receive. So sometimes people have a good or a bad experience in one of them, and so they tend to prefer one over the other. But that's kind of really a personal choice issue.
Well, thank you, Joanna, and Molly. I'm very interested to hear your perspective so on this, looking at it from the state jurisdiction, Anti-Discrimination New South Wales. What would you say are the key things that people should consider?
Thank you, Bruce. I think some of the key things have already been highlighted by Sarah and Joanna. One of the things we'll tell people generally is before lodging a complaint, contact our inquiry service. So we've got an inquiries line. Contact us, and one of our inquiries officers may be able to help you to lodge a complaint, or may recommend an advocacy service to assist you to lodge a complaint. But there are other factors that have been touched on already, also including time frames. So for us at New South Wales, for you to be able to lodge a complaint, that issue, the discrimination, should have occurred in the last 12 months. So if it happens more than 1 year ago, you'll have to provide reasons why you did not lodge the complaint sooner. Because the president could probably decline a complaint that is older than 12 months. So it's very important to take note of that. But if you are perhaps able to provide reasons why you were not able to lodge a complaint before that time frame, perhaps there could be some considerations given to those reasons. And the other thing that is important particularly for people with certain types of disability, or people who might, for instance, have difficulty with language, English language and things like that, is that with New South Wales, you can lodge your complaint in any language. And we provide that support for you in terms of ensuring that language is not a barrier for you to lodge a complaint. So you are able to do that with us. And there are certain other elements that have also been touched on as well in terms of what should be in the complaint. There should be certain information in your complaint if you are lodging one. And that is, for instance, you should be able to state your disability, and you should be able to also state who treated you less favorably. So, but also dates in terms of when discrimination started and when it finished. All factors to consider. We don't take anonymous complaints, so there has to be names attached to your complaint for us to be able to consider your complaint. And you could also use third parties to assist you with your complaints. Say, for instance, you could use an advocate if you don't want to directly deal with the matter, an advocate to lodge the complaint on your behalf. And if you go to our website, you find all that information in the form. All you need to do is to provide, to give them that authority for them to act on your behalf. And so lodging a complaint is not a complicated matter when it comes to the Anti-Discrimination Act. Putting the information that I've highlighted, and if we need more information, we will ask for it. So don't hold back. If you think you have been treated less favorably because of your disability, be it in employment or in accessing goods and services or in accommodation or in public education or clubs, registered clubs, just give our inquiry lines a call, and they might be able to guide you in terms of what your options are. In some cases, like Joanna said, our legislation does not cover things like private education. So if the discrimination took place in that setting, we are not going to be able to deal with that. We will make the necessary referrals to the Australian Human Rights Commission in that case. So too is the example with Commonwealth bodies or agencies. If something happened there, we don't have the authority to look into such matters, so we will make the necessary referrals as well. And in terms of time frames, we have got between 2 to 6 months to resolve a complaint. So that is generally the time frames that we look at. But if the matter is urgent, say for instance, someone is about to lose their job or they're about to lose their accommodation, we will prioritize a matter like that and try to resolve it as soon as possible before the person loses their job or their accommodation. The other thing that we should be considered is that ours is like it's not a formal legal process, so you don't need to prove the case of discrimination. The emphasis is on to resolve the matter. So there's that opportunity there as well, and it's quite a flexible process. So before the pandemic, it largely used to be conducted through conciliation, face-to-face conciliation. But with COVID, we're now doing it online, usually through Microsoft Teams, and over the phone, but also shuttle negotiations using the phone and emails as well. So those are some of the factors and to consider. But the general thing that you should keep in mind is if you're thinking that what you're going through is discrimination, pick up the phone and contact our inquiry lines. We'll be able to give you the options that you might have.
Thank you, Molly. And one of the very clear messages, for me, coming from all three of you, is that look, there are plenty of resources around. There is a lot of assistance that you can call on if you do feel you've been discriminated against, and you want to at least consider lodging a complaint. Because one of the, we often get people saying things like, "Look, I've never lodged a discrimination complaint before, and I feel really nervous about the whole process." And I think you've all kind of domesticated that process a lot and made it and taken a lot of the fear away. While I was interested in your comments around using teams and shuttle negotiations, and particularly as that has become necessary more during the pandemic. Joanna, have you found any changes in the way that you conduct your work because of the pandemic?
I was just going to say, while Marlon was speaking, that same goes for us. So so we also one point of difference. So certainly, yes, you can make complaints in different languages. We can also assist people with print disabilities or with cognitive disabilities to draft a statement of complaint if they have difficulty kind of gathering their thoughts together. Again, you kind of need to provide us enough information for us to know who we're talking to. So who you are, what the issue is, what happened, who you're complaining against. But, you don't need, we're not expecting a legal brief from you. Like we people provide, there just has to be enough information for us to kind of go, okay, there's a clear allegation of discrimination here. If for some reason you don't provide sufficient information, we'll contact you and tell you and ask you for more information. So we don't expect you to be a legal practitioner or anything of the sort. So the point of difference actually, and thank you for pointing that out, we do accept anonymous complaints. The difference there might be that that might limit the way that the process can run, and if the complaint is terminated and you want it to go to court, obviously we'd need to have a conversation with you about that, because you will need to disclose your name to the court. But generally speaking, if it's just, for example, I went to a shopping centre with my guide dog and they were really rude to me, or they kicked me out, but you don't want to say who it was, we can progress that, but obviously it's going to make it very difficult for the shopping centre to respond, because you can kind of say, look, I was there on this day at this time. They still won't know your name or where you live or what your phone number is or anything like that. So certainly with COVID, we have experienced essentially a 100% increase in complaints. The majority of those are disability related. So I think we were actually just talking about the statistics for the current reporting year, which for us goes from July to June. And we're already up to over 50% of all complaints are disability complaints. And certainly, whereas we used to provide face-to-face conciliation conferences, they are pretty much being done on Teams or by phone. So obviously with Teams, you can join online or by phone or through the app. So there's quite a bit of flexibility there about how you participate in the conciliation process. Some people like to use video, others don't. So we're sort of pretty flexible there again. We can conduct face-to-face conciliation conferences when it's safe to do so. So there have been periods during the pandemic where we have been able to do face-to-face conciliation conferences, but obviously we need to make sure that everyone's safe. So probably at the moment, we would only do that if there's some particular reason why a face-to-face conference is required. And so I did see someone ask where we were located. So the Australian Human Rights Commission is based in Sydney, but we cover the whole country. So we're in the Sydney CBD. Yeah.
Just thinking of the of the pandemic reminds me of a question we do get from time to time around the mandates for for wearing masks. Some people for example say that wearing a mask interferes with their vision, or it might interfere with their breathing, and so the question then becomes how can people deal with a situation like that, for example, by not wearing a mask, and how can they sort of deal with that without running foul of the police or assistance in shops and so forth.
Yeah, look, that's certainly been an issue that is responsible for quite a large proportion of the increase in complaints. We've received several hundred complaints regarding mask wearing requirements and various disabilities. Look, I think it's one of those things where this is a novel area of the law. So I think both state and federal agencies are being quite circumspect about the information that they sort of discuss around this issue, because we don't know what a court's going to say. If this matter goes to court, we don't actually know what a court's going to say. But you will find that certainly we have some information on our website, I believe, about mask wearing, and I think other state and territory commissions do as well. I know Victoria was very early out of the cab rank for that one. But look, essentially, if we don't look at, so for us, to a certain extent, it's irrelevant whether there's a state order in place, because federal law trumps state law. So what that means is if there's federal law and a state law and there's an inconsistency between the federal law and the state law, the federal law wins. And most of the mandates, whether they be vaccination or mask wearing, are state-based orders and laws. So essentially what we look at is we just go back to the basics of the law. Is there a requirement or condition being imposed on this person? Is the person able to comply with that requirement or condition? Is the requirement reasonable? Now, obviously, it's never that simple. Unfortunately, states and territories haven't really set up proper mechanisms for people to, for example, register or apply for exemptions. So exemptions under the state orders kind of apply after the fact, which is not terribly helpful, because it makes those conversations very difficult. So, for example, I have an eye condition which is aggravated by humidity, and if you wear a mask, as most of you would know, you're kind of breathing air into your eyes, and that increases the humidity, and so that affects my vision. I spoke to my ophthalmologist. She's written me a letter that says exactly that. Now, I'm still choosing to wear a mask on buses and when going to shops and things like that, because frankly, I don't want the fight of having to explain why I'm not wearing a mask. But because I'm still going into the office, and at the moment in New South Wales, you're required to wear a mask in the office unless you're the only person there, I have sort of provided that letter to my employer and said, when I'm in common areas, I'm happy to wear the mask, but if I'm just sitting at my desk in my office, I will not wear my mask. And they've been okay with that, so that's been kind of a negotiation. I think when you're coming to kind of one-off contacts like shops, buses, cinemas, that's when it gets quite challenging, because, theoretically businesses are not supposed to be asking you about your disability, but obviously it's quite challenging for you if you're kind of saying, I've got an exemption, and they go, well, show me evidence of your exemption. Potentially requiring you to provide that information is a breach of your privacy, which gets you into a whole different complaint space. But unfortunately, it can lead to some quite problematic interactions, and particularly when people also have communication issues or mental health issues, those interactions can deteriorate quite quickly and become really toxic to the point where the person is quite distressed. They might be getting banned from the shop or the restaurant or whatever it is. Look, we are getting a bit of a, we are trying to deal with those quite quickly because they are often one-off incidents, and we're sort of, look, in some cases we are achieving a resolution, in other cases we're not. It really depends on the parties involved and what actually happened on the day. But yes, so the short answer is that yes, you can make a complaint if you consider that you have an exemption. Well, if you consider that the requirement to wear a mask is discriminatory in your case, you may have grounds to lodge a complaint. If your objection to wearing a mask is ideological, so if you do not believe that the government should be telling you what to do, or if you don't believe in masks, or if you believe, and I'm talking about reasons that people have actually given us, if you believe that God is protecting you from COVID and you don't need to wear a mask, if you believe that wearing a mask is unhealthy because you're not breathing enough oxygen, those are not really grounds that you could allege, because it's not because of your disability.
And
so sorry, that's a long answer.
Yeah, thanks, Joanna. And Molly, what's like? Does what Joanna sort of been saying there resonate with you and your experience? With masks and related types of complaints during the pandemic?
Absolutely. So in our case at the state level as well, we've been receiving a lot of inquiries and complaints relating to the use of face masks and mainly related to public health orders that require people to put on masks in certain places. So and a significant proportion of the complaints that we have received about that is about people being refused access to goods and services, such as attending health services or shopping, as well as in employment situation where, such as in medical centers where people required to wear face masks. So we're getting complaints along those lines, and we have been able to resolve some of the complaints, but for others we haven't been able to. And like Joanna said, in a state case as well, if a person has a disability that prevents them from wearing a face mask and has been stopped from attending work or accessing a particular goods and service, they can lodge a complaint, a disability discrimination complaint. And generally we'll use the same process of investigating the complaints and going through all the process, and if the complaint is accepted, then we can do a conciliation, and in some cases we have been successful, in others we have not. So there's a lot of a lot of things are still unclear in this area, and so we're getting that. And there is also recently we've been getting, just relating to COVID, a lot of inquiries as well around, mandated COVID vaccinations, and our legislation does not cover that. So we make the referrals to the website of the Australian Human Rights Commission, but also other websites such as the Fair Work Ombudsman, if it's an employment-related issue, or Safe Work Australia, if it relates to issues of work health and safety law. So so it's an area that is pretty much there's a lot of things that are gray in that space, and but the bottom line is, if you have a disability that prevents you from using a face mask, and you've been stopped from going to work, or you have been refused access to goods and services, you may want to consider lodging a complaint or calling our inquiry lines, because every case might be different. It's not going to be the same situation. So talk to us, and then we'll be able to guide you about what options you've got in terms of your next steps.
Thank you, Mola and Sarah. Just looking at it from Vision Australia's perspective, have we seen any sort of increase in complaints or disability discrimination complaints during the pandemic in general, and I guess in particular around this whole area of mask wearing?
Well, clients have contacted us regarding different difficulties they've had during the pandemic, whether that's sort of an actionable thing that they can put in a disability discrimination complaint against, or if it's just sort of a barrier that they're having trouble with constantly. A couple of the things that they're having trouble with is the community's having trouble locating and using the QR codes if they're out independently, being able to find where they are to be able to get into a venue. And then once you're in a venue, sometimes they're using the QR codes to actually order food. So there's a problem sort of just logistically getting into the venue and then logistically being able to order food once you're inside a venue. Social distancing requirements, quite a lot of clients have said that's quite difficult when you're blind or have low vision. And in fact, there was a survey that was conducted by Vision Australia, and unfortunately, it said that 15% of people reported that they'd been abused as a result, verbally abused, because they weren't able to sort of comply with social distancing requirements, which is disappointing. There's also different sort of situations in terms of when people would go to stores perhaps before COVID. There may be some reasonable adjustments made by shop assistants in terms of offering sort of sighted guidance or direct assistance in terms of guiding people around the store. And of course, with the public health requirements, that sort of adjustments and sort of reasonable adjustments that was provided before are no longer available. So people find that quite difficult. The masks is an issue. Often people report that they have trouble hearing because of the masks, but also when people who are blind or have low vision and maybe are relying on hearing, they've mentioned like ribbon barricades and perspex dividers as in, impacting on them being able to hear and interact and communicate with people at stores. There's also been some sort of website online accessibility issues with particularly early in the vaccine drive with booking vaccine appointments. Unfortunately, early on that wasn't accessible to people using screen reading software, so they weren't able to book their vaccine appointments online, and that's because they're blind and they need that software to be able to make the appointment. Also accessing the PCR sites, and I know the general community had trouble accessing PCR testings for a time, but, obviously with the prevalence of drive-through testing sites, people who are blind aren't driving cars, so they're not able to access that avenue of testing. And then they're reporting also just accessing transport to get there and also filling out forms, needing, again, that direct assistance, people making reasonable adjustments to help them fill out the forms once they are at the testing site. One that's become quite prevalent in the past sort of few weeks to months has been the prevalence of the rapid antigen testing and the fact that they are quite inaccessible to people who are blind or have low vision. They're very visual. The process is visual, the results are visual. And again, that's creating barriers to people being able to access that sort of medical information that's more widely available to people who aren't blind or have low vision. So they're the issues that people have raised with us, and I'm sure there'll be more to come as things continue to unfold during the pandemic.
And look, and I should say that most of those are issues that people could lodge complaints about. So I guess the thing to be aware of, so the thing is to kind of identify who you're lodging the complaint against. So for example, in the case of a drive-through PCR testing site, if that site is just a particular private pathology hired by the health department to run a PCR testing site and they only offer drive-through, it's not really the site that's the problem. It's probably New South Wales Health in terms of how they choose their sites and what modes of accessing those sites they provide. So, you know, sometimes it's about maybe having a bit of a talk to either ADNSW or the Federal Commission about, you know, look, this is what I'm feeling discriminated about. Like, how do I kind of pin down who's responsible, you know, because it might be that it's actually like a state government decision versus an individual decision or something like that. The other thing to sort of just bear in mind is that both pieces of legislation have what are called kind of exemptions or exceptions. So there are certain situations under which it's not against the law to discriminate against someone. One of those is so in the Federal Act, it's not unlawful to discriminate against someone if the discrimination is reasonably necessary to protect public health. So why that was there would be things like, if your kid is sick, your school sends your kid home, that's strictly speaking treating your child less favourably because they're sick, which is a disability. But obviously that's a measure that's reasonably necessary to protect the health of everyone else, right? So what you'll find is, for example, if you were to say, well, okay, the fact that staff no longer provide that assistance of guiding me around a department store or a venue is discriminatory because it limits my access. So my access is being provided on less favourable terms. They might say, well, but that's a measure that we need to take to protect the health of our staff. But, you know, it's never that simple. So again, that's why I was saying, do not be kind of overthinking things when you lodge a complaint. It's just useful to be aware of the fact that there could be an exemption or exception that applies, but that's not a reason not to lodge the complaint, because it's up to a respondent to prove that exemption, that exception applies.
Thanks for panelists. And as someone who also has a hearing impairment, those perspex screens that they put up in counters, that drives me absolutely bananas. And if you're ever with me when I encounter one of those perspex screens, run away, because I become completely feral. So unfortunately, I have to give you some good news. Well, that's the fortunate bit, and then unfortunately, I have to give you some bad news. The good news is that the time is flown by. I said we were going to have a good time, and we have. The bad news is that we're just about out of time, and we haven't yet got to audience questions. Phil, do we have any sort of questions in the chat or in the raised hands that we haven't yet dealt with?
We've got a couple of questions. We've got one from Joanne regarding a workplace incident where she asks, my manager demanded that I look her in the eyes, and Joanne says, I have difficulty looking people directly in the eyes when I'm stressed due to my vision. Is this discrimination?
Arguably, yes.
Yeah. So
that's your advice, but you know, yes, you could lodge a complaint about that.
And we also just have another quick question from Violetta, who's asked. She was travelling on the bus a couple of times and pressing the buzzer to ask for the driver to stop, and the driver on 2 occasions has continued to drive and drop her sort of 3 or 4 blocks away from where she wanted to get off, and sort of, I guess, where that would potentially fall and how to maybe, I guess, pursue that issue.
Yes, again, that could arguably constitute disability discrimination in the provision of goods and services. There's discussion in the transport standards about the provision of direct assistance where, for example, in the case of transport announcements, so theoretically, in an ideal world, your bus would be announcing the stops that it stops at. I'm very lucky. I'm on the B1 line, which is, I think, the only line in Sydney that currently has bus stop announcements. But if you're not, then you can ask. The way for them to comply with the standards is to provide direct assistance, which is for the driver to tell you where to get off. If that's not happening on a consistent basis, you certainly have grounds to lodge a complaint. I note that I think one of the questions, Bruce, that audience had asked is how to have systemic impact in your complaints. I would actually say every complaint has impact. Every complaint is an educative process for both complainants and respondents. But, you know, certainly you could do what Graham Innes did with Railcorp, which was to lodge a complaint every time something like that happened. So I think we ended up with like 37 complaints in the first batch. And what that meant was that when he went to court, the court actually considered every single instance, and when he was successful, awarded him compensation for every single instance of there not being announcements on trains. So, you know, yes, you could lodge a complaint, I suspect, with either agency.
And one of the things, Sarah, I mean, we one of the areas that your team deals with, isn't it, is around, you know, discrimination in workplaces, and also, you know, things like bus drivers, recalcitrant bus drivers, and so forth. So that's the kind of thing that we can assist people with.
Yeah, we can definitely assist people with any access to transport issues or any reasonable adjustment issues with employment. They're definitely things we can talk to people about and either attempt to resolve or help them with a discrimination complaint.
And so, Sarah, what's the best way for people to get in touch with the Vision Australia's advocacy team?
Okay, we've got the advocacy email, which is advocacy@visionaustralia.org. That's one way to contact us by email. Otherwise, you can phone the main Vision Australia line and just ask for a member of the advocacy team, and we can assist you and we can talk through the issues and see what next steps we should take.
I want to thank firstly our panelists for making this such a fantastic webinar. I must say, when I was thinking about it back in the early stages, I thought, how are we going to find enough information to talk about for 75 minutes? And of course, what's happened is we've barely scratched the surface, and I think that shows what an important issue it is. We all experience as people with disabilities discriminatory barriers, and it's really important that we find effective ways of dealing with those. So I do want to thank our three panelists, Joanna and Morai and Sarah, for contributing your expertise and sharing your perspectives tonight. And I especially want to thank the audience. We've got about 35 participants, I think, tonight, and that's really good. A number of people registered and weren't able to attend, so they, as well as you, will be receiving the recording when it's sort of sorted out in the next few days. And remember that if you do have any questions that we weren't able to cover tonight, please feel free to send them to advocacy@visionaustralia.org by Friday afternoon this week, and we'll submit them to the panel. So again, look, thank you.
Oh, and sorry, Bruce, I think I saw on the chat earlier someone asked for a link to how to make a complaint. So what I'll do is that when I'll wait to see if there's any questions, and when I send that back, I will also send some links to our complaints information page and information about our National Information Service and so on, so that you can find that information easily.
And Molly, you'll be able to do that as well, will you? So we can have a sort of little collation of resources. That would be very useful.
Absolutely.
All right. Well, look, thank you very much. It's been a great webinar. It's been my privilege and pleasure to facilitate it. Take care, stay safe, and stay tuned for the next Stand Up for Your Rights webinar.
Thanks, everyone.
Thank you.
Thank you.
Vision Australia.
Blindness,
Low vision.
Opportunity.
Vision Australia logo. 3 navy blue ovals linked together diagonally within a bright yellow rectangle.